Hi guys, welcome to 5mantra.com. This is Rajesh, Faculty of Gender Studies, is here before you to explain you the multiple choice questions from the Gender Studies paper 2 subject called Indian Polity and Constitution. So in our series of MCQs of Indian Polity, today's video will explain you the fundamental rights chapter. So coming to the fundamental rights, as you all know, this fundamental rights constitutes the part of third part from the articles 12 to 35, which has been given to the citizens and some of the fundamental rights to the non-citizens of the country by the Constitution of India. So what is the essence of these fundamental rights? I'll let you know by doing some critical questions on these fundamental rights. Okay, so let us go to the first question. The first question is, entitlement of legal aid is a concomitant right that arises out of fundamental right. This is a question. So here the terminology concomitant meaning subsequent right. Okay, this is consequent right like. So the options are as follows. So that right arises out of the fundamental right to freedom or against exploitation. Second option. Third option is to equality before law and or equal protection of laws. And fourth option is all of the above. So if you carefully observe all the options, entitlement of legal aid will gives you the freedom to raise your voice against the injustice happened to you. Okay, so to the freedom, so the option freedom justifies the question, so it would be the answer. And coming to the second option, against exploitation, obviously injustice means it's a phenomenon, it's a situation where the exploitation is done to you by someone or some system. Okay, it's a part of the system like. Okay, then this entitlement of legal aid has been given to you to raise your voice and complaint against that exploitation happened against you. So the second option seems to be also the justified answer for this question. And third option, to upheld the equality before the law or equal protection of law. Obviously these two are the components of rule of law advised by A.V. Dicey, which I have explained to you in the earlier classes, and these two components can be also justified through the entitlement of legal aid provided to you guys. So these three options gives you the perfect justification to the question, and the last option is all of the above. That would be the answer. So the answer for this question is option D, all of the above. So coming to the second question, a fundamental right guaranteed in the Indian Constitution can be suspended only by. So here we are talking about the suspension of fundamental rights. So the first option is as follows: by a proclamation of national emergency. Second option is by an act passed by the parliament. Third option is by an amendment of the constitution. And last option is by the judicial decision of the Supreme Court, that is Apex Court. So here, as I told you in the earlier classes, during the proclamation of national emergency by the president, or not only the national emergency, it could be a state emergency, then in that situation, through the presidential order, a notified set of fundamental rights can be suspended except 20 and 21. And when in the case of state emergency, 19, 20, 21 will be alive, and the remaining can be suspended by issuing a proclamation, that is presidential order. So the fundamental rights guaranteed under the constitution can be suspended only by a proclamation of national emergency by the President of India, not any another situation. Okay, only this situation suppose this suspension of fundamental right as per the provision which got borrowed from Weimar Constitution of Germany by our constitutional experts. Okay, and the remaining by an act by the parliament or by an amendment to the constitution which is done by the parliament, and the judicial decision of the Supreme Court, has these three provisions has no power to suspend fundamental rights, because the fundamental rights acts as a control or impediment upon the organs like legislature, that is parliament at the central level, and the state legislature at the state level, and the executive both at the center and the state, and the judiciary also. So they act like a regulation or impediments for the arbitrary action which are done by these three organs, that is a legislature, executive and judiciary. So the rest of the option B, C, D, where the act passed by parliament, amendment of the constitution and judicial decision of the Supreme Court will not support the suspension of fundamental rights by, except by only a proclamation of emergency, that could be a national emergency or state emergency, by the President of India. So the option A is correct for this question. And coming to the next question is, how can the fundamental right can be suspended? Obviously you can solve the question easily because I have given you the insights on this. So first option is if Parliament passes a law by 2/3 majority. Second option is if the Supreme Court orders it, and third option is if the President orders it in the time of national emergency, and fourth option is they can never be suspended. No, not like that, they can be suspended by a proclamation of national emergency by the President. Hence option C is the correct answer for this question. So coming to the next question, how can the fundamental rights be protected by a citizen? Obviously fundamental rights are given to us, we are the citizens of India, so our rights should be protected. And who is going to protect our rights? Who is going to come into the picture when our rights get violated? When we are being denied with the fundamental rights by a person or by a part of the system, then who will come into the picture? That's the question. So first option is by approaching the Supreme Court, which will issue appropriate writs against the authority. Okay, first option. Second option, Parliament will take note of such violations and tell the courts. Third option, the executive will inform the courts. And D, it is automatically protected. So if you deeply develop your insight on the fundamental right, your fundamental right can be protected and will be protected by the judiciary, because judiciary, particularly the Supreme Court and the higher courts, that is higher judiciary, are the protectorates of fundamental rights of citizens in our country. So how could this judiciary will protect the fundamental rights? Through the instrument of writs. We have 5 writs, guys: habeas corpus, mandamus, quo warranto, prohibition and certiorari. So these are the 5 writs through which the higher judiciary, either the Supreme Court and the High Court, will restore the fundamental rights of us which got violated by the authority. Okay, so the first option, that is by approaching the Supreme Court, which will issue the appropriate writs against the authority, is the correct answer. And approaching the Supreme Court for restoring your fundamental right is also a fundamental right under Article 32, you know. So you can restore your fundamental rights by exercising your fundamental rights. But be careful that if you approach the High Court for your restoration of fundamental rights under Article 226, it's no longer a fundamental rights. Okay, it is a constitutional right provided to you so that you can approach High Courts for the restoration of your fundamental rights, and that High Court will issue appropriate writs for the restoration of your fundamental right. When coming to the Supreme Court, it is your fundamental right to approach the Supreme Court for the restoration of your fundamental right. Okay, that's cool. And coming to the next question, can Parliament amend or modify any of the fundamental rights given in the Constitution? Let's see, can or cannot. So first option, Parliament can do so only after a referendum. Second option, Parliament can amend them by special majority. Third option, Parliament cannot amend any of the fundamental rights. And last option, only the President can issue direction to amend them. So here, even though the fundamental rights are absolute in nature, are not absolute in nature actually, it can be subjected to the amendment but not to the suspension. That is what I mean to say is, even though these fundamental rights are generally not subjected to the suspension except in the case of emergency situation, these fundamental rights can be amended by the competent authority called Parliament. Parliament can make a law regarding the amendment of these fundamental rights. Okay, so for example, we can see the 44th Amendment Act, which scrapped away the right to property from the list of fundamental rights and made it as a legal right under 300 years. This is a classic example of amendment of fundamental rights which got upheld by the Supreme Court also. But here you need to know is, this amendment will be may be subjected to the judicial review by the judiciary, that too the judicial review by the Supreme Court. So in that exercise of judicial review, then this amendment should be justified with a justification, with a reasonable rationality. Then the judiciary will uphold that particular amendment to the fundamental rights. Otherwise, the amendment of the fundamental rights which violates the fundamental right of a section of citizens will not be held by the Supreme Court, and it can be declared by the Supreme Court as null and void under judicial review. Okay, so the option B, Parliament can amend them by a special majority. That's the correct answer. And coming to the first option, Parliament can do so only by a referendum. That is after a referendum. So here, what do you mean by referendum? Referendum is a process of which a particular proposal or bill will be submitted directly to the people, and the people will be asked their consent to the bill, whether they are yes to the bill or they are no to the bill. So that phenomenon, that instrument is called referendum. And referendum is one of the instrument under direct democracy, but we are practicing indirect democracy, or otherwise called as representative democracy, where we have no place for the direct democracy instruments like referendum, recall, initiative, plebiscite. So in our democracy generally. Okay, so I hope that you got a clear perspective upon this referendum. Okay, so for this question, the second option, Parliament can amend them by a special majority, is the correct answer. So coming to the next question, which statements indicate the difference between fundamental right and directive principles? So first option, the directive principles aim at promoting social welfare, while fundamental rights protect individuals from state encroachments, for first option. Second option, the fundamental rights put limitations on state action, but directive principles are positive instruction to the government to move towards a just socio-economic order. That's the second option. Third option, fundamental rights promotes the political justice, where the DPSPs promotes both social and economic justice, which is called distributive justice. Okay. Fourth option, fundamental rights can be amended, but directive principles cannot be amended. That's the fourth option. So which of the following options gives a correct and clear differences between the fundamental rights and the directive principles? Let's rationalize all these options. Coming to the first option, the directive principles aim at promoting social welfare, while fundamental rights protect the individual from state encroachment. So coming to the DPSPs, directive principles of state policy in our constitution is under part 4 from article 36 to 51. So these directive principles of state policy aims to guide the government policy towards the social welfare. So obviously it is promoting the social welfare. And coming to the fundamentalists, as I told you earlier, that it protects us, that is, it protects the citizens or individuals in our country from the arbitrary actions of the state. Arbitrary actions means the actions which are not acceptable by us, and the actions which violates our rights, which violates the fundamental rights. So then these fundamental rights protect us in order to in order not to subject to the arbitrary actions from the government, from the state. So first option is correct, and it is a clear difference between DPSPs and fundamental rights. Coming to the second option, the fundamental rights puts limitations on state action, but directive principles are positive instruction to the government to move towards a just socio-economic order, obviously. So the explanation for the first option, if you carefully look at that explanation, then you can justify the second option, that fundamental rights acts as a limitations on the arbitrary actions of state. Like fundamental rights are negative in nature, but when coming to the directive principles of state policy, they act as a guidelines to the state in order to frame their policy to walk towards on the lanes of social and economic justice. So they are positive in nature. So from this rationality, you can sense that the second option gives a clear difference and correct difference between fundamental rights and DPSPs. So coming to the third option, that is fundamental rights promotes the political justice, where DPSPs promotes the social and economic justice. So guys, here the point you need to know is the justice which has got place in the preamble of our constitution. So the justice will be provided to you politically, socially and economically. The political justice is assured by the fundamental rights, where you have been given the right to participate in any of the public employment, including including getting the due representation in our democracy also. That is also your fundamental rights. So fundamental rights fosters the political justice in our society, and when coming to the DPSPs, they fosters both economic and social justice, where these DPSPs act as the guiding principles for the state to achieve the society with a just social and economic order. Do you know both the social and economic justice combinedly will be called as distributive justice, which is very necessary for the personal improvement of any citizen. Okay, so the third option is also a clear and correct difference between these two concepts, that is called fundamental rights and DPSPs. And coming to the last option, a fundamental right can be amended. Obviously it can be amended, I have told you, but directive principles cannot be amended. No, it also can be amended. So these fundamental rights can be amended, and also the directive principles also can be amended. So it is a difference, but it is not the correct difference, because the statement itself is wrong. So you can eliminate the fourth option, and come into the options, you can choose the D option, that is 1, 2 and 3 are the correct options. Clear? So coming to the next important note and a note point to you is, see, fundamental rights are legally justiciable, that is judicially justiciable. You can approach the court, either High Court and Supreme Court, okay, under Article 226 and 32 respectively, if in case your fundamental rights got violated for the restoration of your fundamental rights. But in case of directive principles of state policy, there is no such provision, because they are not judicially enforceable. If, for example, if government fails to enforce any policy on the lines of directive principles of state policy, because of maybe due to the lack of its resources, then you cannot approach judiciary to make it enforce. Okay, that is the key point you have to take care of. So this is the critical questions. These are the critical points and explanation regarding fundamental rights, guys. So hope you enjoyed this video, and if this video is informative and help you for your preparation, please raise your thumbs and follow us the 5mantra.com for more updates. Thank you.